course, is equally sits at the Court of Appeal in Michael Rotich versus Republic. And we preempt that the defense are likely to run away with Michael Rotich, so we are going to hit hard on it before they get the chance. In summary, what we are requesting this court to do is to issue an order for what the Constitution calls detention continuing. So that the respondent remains in custody, that's the common name that we call it custodial orders, for purposes of completion of investigations. Cognizant of the limited jurisdiction of this court under Section 8, subsection 2 of the Magistrates Court Act 2015, our references to Article 29 is only in passing and for purposes of laying basis. That every person, I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. In further laying of the basis, that Article 24 of the Constitution allows for limitation of right under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification. And where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important to us, informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joel Ngugi J, as he then was, in Sudi Oscar Kipchumba.
If I get directions, the DPP is making submissions.
Yes.
They waive the right of making submissions after we have made our submission, so that once they have done this, they will surrender the witness for cross-examination, and they'll have no bite. procedurally, it is the deponent to be put on the dock. And the deponent is cross-examined. The respondent's lawyers submit, then the state submits. But now it's the past. And that's why I'm asking. Is my GOtv applicating the law?
My understanding was that he was just laying a basis so that once the deponent comes to the dock, then they can proceed from there. Yeah. So let JB just finish with your laying your basis. I believe it's more or less like an opening statement.
He has done an opening statement.
Yes, let him finish.
Then be doing an opening statement.
He did.
To lay the basis.
Yes.
And counter what has been said. Because he's doing actually an opening statement. We'll also be seeking that we also put an opening statement and before the court.
So please proceed.
Sorry, Your Honor. I do not understand the basis of that argument, because we are arguing our application with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts. So I'm almost done with the law. But sometimes he does that to take me off-road, and he knows I never did off-road.
It's his strategy.
Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Joel Ngugi, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial orders. And it says, at paragraph 24, if you permit me to read, so even while accepting that the text of Article 49(1)(f may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that, Your Honor, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interests. You know, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And Your Honor, the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by these quadruple interests, and without refining or essentializing any. You know, I dare say kizungu kubwa. having highlighted those two tests, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. Your Honor, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interests, and as equally important, the interests of the public to ensure safety and security. You know, with that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am also obliged unless there's a question for me.
All right, thank you. Thank you, Counsel.
Your Honor, Makori.
Yes.
Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Dated the 16th of June 2025. It is an affidavit in support of the notice of motion dated the 16th of June 2025. Your Honor, I will only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation. And these are the preliminary investigations by IPOA, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious publications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6B. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10, 7/7/6/2025. That is 10/7/6/2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6/2025 and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6A the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested. And this is something that we wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigation.
Now, still I'm asking, what will be the respondent be telling this court?
Your Honor,
The information the DPP is giving, it's not them who deform. It is the one who deformed who should be giving us those paragraphs in paragraph 4. Then the DPP can buttress their submissions based on that. Right now, the DPP is turning himself into a witness. And you cannot go examine the DPP. It is fair and just. The witness who deformed takes us through his affidavit.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of.
You know, that's a dicey. It's a dicey situation because
Yes.
you know you're literally taking us through the affidavit. But I leave because I'm sure you have your own strategy
Yes.
on how to prosecute the application.
The
But don't
defense-
go into details of the affidavit. I'm sure the deponent will have a chance.
Yes.
So I'll leave you to proceed, but don't go too much into it, the details
No,
of the deposition. Yeah.
Now, Your Honor, I'm only highlighting
Okay.
some paragraphs. I'm not going through the whole affidavit.
Indeed,
Because
indeed.
they have already indicated that they want the deponent on the dock
Indeed.
for cross-examination.
Okay.
Yes.
So you're referring to the CCTV, maybe to refresh,
yes,
to recap.
the CC, yes. He said paragraph 10.
Yes.
The respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigation. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. And it is subject to investigation. Your Honor, there are also witnesses who are yet to be investigated and the statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there is a likelihood that he may interfere with the investigations. Seeking the 21 days. To continue holding the respondent, and in addition to the 21 days, Your Honor, we will be seeking an order that we access the forms of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference which has already been done. With that, Your Honor, we will be inviting the deponents, the doc, for cross-examination.
You can testify for this one.
Yeah, wherever you're comfortable.
Yes. It's comfortable there where you sit. You will be seeking that these are turned into an opening statement. You'll be allowed to put a 3 minutes opening statement.
No, let him finish.
What?
Let him finish, and then you'll have your chance, yeah?
What?
Let him just finish, so that there's that continuous flow. So you can show yourself. Is there...
Bismillahirrahmanirrahim. I swear by the name of Almighty God, that the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God.
This state to the court, you are free.
Your Honor, I am Abdurrahman Jibril. Jibril for you, Jibril. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes, did you recall this affidavit of the reporter?
Yes, Your Honor.
Yes, kindly proceed with the affidavit.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPO is currently conducting in regards to the brutal Albert Ojwang. This is pursuant to Section 6, 7, and 25 of the IPO Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. You can only adopt them from the facts. Because unless there's any other crucial information.
That's all right, that's okay.
Yeah, I was of the view, but just give a highlight, not necessarily going paragraph by paragraph, just a highlight, and then we can adopt it. Just a brief highlight, yeah? You okay with whatever you've said so far?
Yes.
And whatever you've averred in the affidavit, yeah? So we can proceed with the cross-examination then?
Yes.
Is that okay? The other team from the state?
That's actually not that.
Okay.
They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness, Mr. Jibril.
So, Mr. Dunson, maybe just for housekeeping in good order, how many of you will cross-examine you?
3.
3. You, yourself, and who else?
Me, what? Kangai.
So only 3 of you from
Yes,
the battery of
examine.
the 3 of you.
Others will submit.
I think that is okay.
Mr. Jibril,
Yes, Your Honor.
can you confirm your position at IPOA over this matter?
May I ask you my rank?
Oh, yes. That's a must.
Your Honor, as indicated, I'm a Senior Assistant Director in Investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or the position of the National Police Act?
IPO Act.
Under IPO Act. And under IPO Act, is it true that you have still arrested crowds?
Yes.
Under which section?
Your Honor, Section 7 of the IPO Act and Section 7 of the IPO Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. Which section?
Both Section 7 in the IPO Act and Section 7 of the IPO Regulations Act.
Gives you the powers as that of a police officer.
Yes, sir.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, sir.
Are you well conversant with the law?
Depends on which area you want first.
And are you, you know, some of us went to teach them, we became lawyers. So people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we'll have an objection.
Yes. I've not asked the question.
We can see. Your Honor,
I've not asked a question.
Your Honor, at least should I be allowed to make the objection?
Yes.
Of what?
Let me just object, then you
No. You wait until I ask. I've just told to look at it. It might be just to admire it. Allow me to ask.
Your Honor, we'll be requesting the court.
That's a normal.
Yes.
But let's hear his objection.
That's right.
Yes, kind
Your
of.
Honor, the witness before the doc
Yes.
has come here on the basis of his affidavit on the factual matters. And that explains why the defense requested that my colleague, my learned senior, does not go into the facts. Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law. And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument in a sense is that this matter, now we have had a copy, although it's not filed,
Okay.
this matter should have been the subject of an inquest and not a miscellaneous application.
Okay.
So that because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed.
Okay.
But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
But Your Honor, is the law a fact? Yes, it is. Is he in a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are fearing and telling us we are coming through the window? If we come through the window, please respond and throw us out of the house.
There is a submission.
You know,
I've not asked any question. I've only told you to look at that section.
but just for guidance, you know, it's a matter of evidence, on the facts. It's an affidavit, for heaven's sake. So let's limit it to the facts of the.
After I've asked the question,
Yes.
then that is when an inference can be done, whether it's a question of law or a question of fact.
All right.
I've not asked what. I've only told you, look at section 380.
Your Honor,
Only
just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination to the contents of the affidavit.
True.
There is no reference to the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are pleadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
I think he was referring to section 386.
Yeah, I just only
So
told you.
let's not convolute it. Let's limit. It's an affidavit.
Purely, I've not asked any question, Your Honor. If we only had what I've asked you, and I ask a question of law, then the court can stop.
Okay, then proceed and ask.
Let him have that. Let him look at what.
But you know, once you point it to the law, then it means it's
No.
it's a point of law.
And that exactly is our objection, that we can't refer to the law. That maybe, see, a counsel is not understanding our objection.
Very well.
Maybe counsel, maybe rather than asking him to look at the law, yeah, why don't you put the questions to him?
Correct.
Just put the question rather than us going to the.
Very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the PO Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
You know, we are still objecting.
Yes.
Council is still taking the same route.
He came under the Act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court.
Don't give him answer. Don't give him answer.
And this is a witness.
This is our witness now.
He's not an advocate. Let him come in front of you. Let him not be given answers.
No, Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to refer to the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of the Act.
Please read for me so that I can answer.
No, you read it. I did write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1 and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is you as in your affidavit taught the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. That is simple.
I have indicated the sections. 6.1, 7.1.
Tell the court. Just tell the court.
Yeah, Honor, I have indicated section 6A, 7.1 and 25.1 of the IPOA Act.
Could you kindly read to the court those sections that gives you that mandate? The IPOA, just read to the court those sections, the benefit of the whole one. Don't work for IPOA.
Neither do we.
Your Honor, because we